Hello, it's Abby. This video is going to be a little different. No genie today, and in terms of animations, it's much simpler. But let's get on to the case. The Supreme Court decided the blockbuster case Fulton v. City of Philadelphia last Thursday on June 17, 2021. The decision was unanimous and held that Philadelphia violated the Free Exercise Clause by requiring a Catholic foster agency, Catholic Social Services, to certify same-sex couples. However, today's video won't be so much on Fulton as it will be on what Fulton, in another blockbuster case, Masterpiece Cakeshop, didn't address. The focus is going to be on a 1990 Supreme Court case called Employment Division v. Smith. Smith began when a drug rehabilitation center in Oregon fired its counselors, who were both members of the Native American Church. The Native American Church combines Christian teaching with traditional Native American beliefs. In line with church ritual, Alfred Smith and Galen Black ingested peyote, which is a hallucinogen illegal under Oregon law. After they were fired, Smith and Black filed for unemployment compensation. However, Oregon refused to give them benefits, claiming their dismissal was due to work-related misconduct. Smith and Black sued, arguing that by denying their benefits, Oregon violated their First Amendment rights. After years of legal battles, which involved going to the Supreme Court twice, the workers lost. In the majority opinion, Justice Antonin Scalia defined the reach of the Free Exercise Clause. This clause prohibits the government from penalizing someone for their religious beliefs or actions, provided that they are penalized on account of the religious beliefs behind that action, or the beliefs that action displays. The Supreme Court held that the Free Exercise Clause stops there. This means that for laws that don't penalize you for your religious beliefs, but are instead neutral and generally applicable, you have to comply, even if they conflict with your beliefs. Some examples, as cited by Justice Scalia, include laws that prohibit polygamy or require military service. Smith is a pretty controversial case. Some think it's necessary for society's well-being, while others think it's a step back for religious liberties. Former American Civil Liberties Union President Nadine Strossen even went so far as to call it the Dred Scott of First Amendment law. That's a summary of Smith, but I do want to bring this back to Fulton. How are these two cases, over 30 years apart, even related? Well, the Supreme Court ruled that Fulton lies outside the scope of Smith, but the concurrences are telling. In a concurrence joined in full by Justice Brett Kavanaugh and in part by Justice Breyer, Justice Amy Coney Barrett wrote that there are, quote, serious arguments, unquote, for Smith to be overruled. In a separate concurrence, Justices Alito, Thomas, and Gorsuch went farther. They said that Smith was wrongly decided and should be overturned, not just eventually, but now, through Fulton. Until this happens, Alito wrote, cases of similar nature will continue to come to court. The court didn't overturn Smith last Thursday. But can it? The answer is, it's possible. That's a summary of Employment Division v. Smith, the case Fulton didn't overturn. Hope you enjoyed watching.